What is a trust? Right, we've looked at all the other relationships very briefly. What is a trust? Question mark. Now I'm going to read a definition of trust. Another book that you might want to write down, which I teach from. Very good book, very good author. Alastair Hudson. That's a professor, University of London. I think he's got some good material online as well you can listen to, like some podcasts. You may or may not get it initially, but the guy knows his stuff, and his books are extremely good. And this book I'm reading from is called Equity and Trust. It's the 6th edition I have, by Alastair Hudson. And I'm reading from page 47. And he says express trust, which we're going to be talking about. There's many types of trust, but we only deal with one type of it, which is express trust, which I'll go into in a minute. But I like what he just says. Says a description of a express trust might run as follows: a trust is created when the absolute owner of property passes the legal title in that property to a person, normally a trustee, to hold that property on trust for the benefit of another person, which is typically the beneficiary. All right? In accordance with the terms set out by the set law. So he's been very polite there when he says in accordance to the terms. He says there are 3 legal capacities to bear in mind in the creation of a trust. You have something called a set law, the trustee, and the beneficiary. And these 3 capacities form what he calls a magic triangle. So we're going to look into that just very briefly. That's a very basic but very good definition of a trust. So Alastair Hudson, it's a very thick book, but it is a very good book. I teach from it. There's a lot of gems in that book. Equity and Trusts. Okay. Can you all hear me still? I'm just hearing a little bit of feedback in my headphones, just making sure you can hear me okay. Just type in a Y if you can still hear me clearly. There's no dialect voices or anything like that. Can everyone hear me still? No sound. Okay, what? Is it no sound because I was quiet? Can you hear me now? Just making sure. All right, good. All right, we're on track. Brilliant. Okay, so thank you for that. Right. Now, triangle, trusts. We have the one who creates a trust. In English law, they're called the set law, S-E-T-T-L-O-R, the set law. In America, can be used or known as trustor, okay, or grantor. All do this, effectively do the same function, effectively. But in UK law, we have the set law, all right? We have a beneficiary. We have a trustee. It can be more than one trustee. There can be more than one beneficiary. There can only be one set law, okay? And each one of these capacities, as Professor Hudson has mentioned in his book, I would prefer to say each one of these capacities are relationships. They're 3 distinct and separate relationships. Everyone has their role to play, and if they play it properly, then life is good. All right, now I'll probably go more into the history of trust tomorrow when I talk about equity, but effectively what the textbooks tell you that came back in the early English history. I think there's even traces to North Africa and certain things, but effectively in English history, the soldiers would go out to war, and so to protect their estates, they would put it into trust with somebody at home. So in case they died at war, that there'd be someone to manage their estates for their family, etc. And that was kind of the beginning of trust. Personally, I don't believe that. I believe trust stems all the way back to year dot. And I can prove that. I'll read some biblical text to you, and it quite frankly, it proves to me that there's no other book that proves to me more than the Bible that tells me who I am and what I own. It says that I was given possession, that I own everything on this earth, and you, not just me, but you and I, we are all the benefactors of this earth. We are all the owners of this earth, and so therefore we have possession, and if we have possession because we own everything, and since we have the power, which makes perfect sense why this money system works the way it does, then we're the one who can grant or put things into trust because it was given to us. So the very first trust was actually in the book of Genesis, but I'll prove that to you probably tomorrow. So so the settlor owns something. He has full, what we call, rights, titles and interests in property. Now, property could be anything from, well, property can be tangible, which is physical. You can touch, taste, smell, well, touch, taste, and at least see it. So it can be tangible or intangible. It could just be a piece of paper. It could be a certificate evidencing you own air in a bottle and no one's claimed it. Yeah, it could be rights to something. It could be copyright, whatever it may be. If you can prove that you're the full owner to it and you have rights to it, interest in it, and title of it, then you are the settlor. All right, very important. It's yours in full, okay? Not partial ownership, but full title. Very important. Full title. So therefore, once you understand that relationship, that's the settlor's role. His job is to put or deposit funds. We call it funds. Historically, it's the res, which is the property. All right, he puts that into trust. The trust is like a black box. It's not physical in any way. It's just a relationship, and everyone has their part to play. And each person's relationship is predicated on the property that is in trust, deposited by the settlor. So the settlor, Professor Hudson said, use the word, creates terms. I think that's a very loose and probably not an accurate definition. The settlor creates law. What the settlor says goes. The settlor is the king. I don't care in what jurisdiction, whether you're in the current Admiralty jurisdiction right now, whether you're at law or in equity, doesn't matter. What the settlor says goes. He's the lawmaker. Even statute supports that. Law books supports that. The settlor is the one who creates the terms. All right. Now you have different types of trusts. To keep it really simple, you've got what we call inter vivos, which is a trust created whilst you're alive, and then you have what's it now? Just slipped my mind. Basically, with wills and probate, but effectively in death, intestates, etc. Thank you. Testamentary. All right, so that's created in death. So that's all related to wills, etc. All right. So we're dealing with living trusts. All right. Now, effectively, the settlor, he creates the law. All right. What he says goes. But you have to own that right. You have to own that knowledge. You have to not accept my word for it. You have to know it. And this is probably the biggest hurdle when you're learning and studying and implementing trust. Because the main question asked is, can I do that? Which means you're not fully sure of who you are yet or what you can do. If I say you can do anything, then there should be nothing limiting you. It comes back to the Matrix, effectively, isn't it? You know, Neo had to learn that nothing could stop him. Because he's been programmed all his life that he had limitations, and then he gets out of the Matrix, and he realizes that he can be suspended in air for how much minutes if he wanted to. He can dress how he wants. He can taste what he wants to taste. He can live how he wants to live. He can be indiscreet. He can be completely oblivious to the public. It's up to him. All right. He can dodge bullets once he was ready to do so. He could stop it. He could read the Matrix itself, etc. Why? Because he had to realize who he was. And it's the same thing for you. You've got to learn who you are and understand that you are the lawmaker. All right, so question. So ideally, in creating a trust, I want to be both the settlor and the beneficiary in the ideal world. Now, it may be ideal for you to be the trustee. It depends on each individual specific relationship that you're trying to establish. But ideally, you want to be the beneficiary, yeah, 9 times out of 10. So, effectively, the settlor is the lawmaker. What he says goes as far as his trust is concerned. Now, once the settlor... So when the settlor creates the law, this is what we now call the decree, or effectively a declaration. Right now in America they say, I've even forgot what I use now, the, oh forgive me, indenture, which is a very old English word, which is no longer used in law in this country. It's archaic. All right, and I know that because I had a High Court justice tell me that when we were talking about trust in the courtroom. So I realised that I can't be using these American terms anymore. If we're going to do anything in this country, we're going to have to make it completely UK specific. So we don't use the term indenture. If you've heard that before, it's better to use declaration. And the settlor declares what he wants. He makes a declaration. He is the king. It's kings that makes decrees. It's the kings, and it's a generic term, ladies, by the way. It's not just male specific. It's generic. All right, we're all kings. All right, so therefore, we make declarations. We state what we want. All right, so therefore, you're the lawmaker, and you must understand that, and you must have that knowledge, and you must own that knowledge. It's not good enough for me just to say, Richard, you know, whoever's on the call, you know, Gary, whatever it is, Paul. By the way, you're the lawmaker. Just accept it. No, you have to own that knowledge. You have to know in the fibre of your being that what you say goes, and you stand on it. So you're the settlor. You declare. When you declare, that's the law. It's as simple as that. And only kings make declarations. Simple. So that's the settlor's role. Once he puts his declaration in and he deposits what he wants to go into the trust, all right. So he puts it on his res into trust. The settlor comes out of the relationship because the relationship now turns into a different scenario. All right, so he steps out of the picture. So let's get back to our triangle. So what you're going to have to look at is you have the settlor, he declares, and he has ownership. We're going to use that term because we're talking about the real man now, okay? The ownership is evidenced by title. Don't get me wrong. But he has ownership, okay? He has full title, all right? Absolute title. Alloidial title. Right? Full control, full rights, full everything. Okay? Full title. That's the settlor's role. So therefore, now, when he puts that into whatever he owns into trust, the title splits into beneficial and trustee, which would be what we call legal title, or we could say possessory title. The trustee holds on to the physical property, but he knows his relationship is only to look after it on behalf of or for the benefit of the beneficiary. Does everyone understand what I just said? I repeat it. The settlor creates a trust. He puts his declaration, his laws, his terms of what he wants the trust to do. The one who administrates a trust is called a trustee. The administrator of the trust normally has possession of the thing, whether that's physical, tangible or intangible. The trustee has possession of it in one way, shape or form. We'll discuss that shortly. On behalf to benefit the beneficiary. So let's give an example here. We have a car. I'm going to call the car a Phantom Rolls Royce. Okay. Right. So that's the thing that's in the possession of the settlor. He says, right, I want my son at the age of 21 to drive this Phantom. However, he's not going to be responsible for any bills, any fines, fuel costs, insurance, the whole work. No, that's not his responsibility at all. I don't want him to pay any of that stuff. That's not his job. I'll give that to Jeeves. Right? My son just needs to enjoy the use of the Phantom. But as far as the administrative parts of owning this car is concerned, no, Jeeves will look after that. So Jeeves, my friend here, here's the keys. Hold these keys in trust for my son. Whenever he needs the car, allow him to use the car. However, if it's damaged, if it needs refueling, insurance is due, etc., 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 Jeeves, you are responsible. Here's some money to sort it out. A trust has now been established. The father goes on holiday, goes on business. He forgets about it now. The trust is in place. Jeeves is what we call the legal owner. He has possessory title to the car. The V5 document will be in the name of Jeeves, but the son just drives it. If the son gets a parking ticket, who gets to pay it? Jeeves. How do I know? The father, the settlor, made law, told in the law in his declaration, Jeeves, pay up any bills. Here's some money, here's some assets to sort that out. Is everyone still with me? Have I lost you? Because you've got to get this part, else when I go to the next stage, I may lose you. So please tell me if there's any discrepancy here, or if you're confused. This is not school. I'm here to teach. So if anyone is lost in any way, please feel free to ask the question, and I will do my best to explain. Right, so the person that said they're slightly lost, just ask away. All right, so I can at least try and go over it again. Do you want me to go over it again? I can do that. It's not a problem. So the question, so is the title, so the title is passed to Jeeves. The legal title. All right, so we have, imagine this rectangle, it represents full title. All right, and when the settlor gets involved and he assigns a beneficiary and he assigns a trustee, that title is now split, right, into what we call legal title. All right, that goes to trustee, and then we have what we call beneficial title, right? The use of the thing, right? It normally represents the beneficiary. So beneficial title goes to the beneficiary. Legal title, or sometimes known as possessory title, goes to the trustee. All right? So in other words, the settlor has full title. Once a trust is established, the full title is split into two separate titles: legal or possessory, and beneficial or equitable title. All right. So analogies to making things clearer. Yeah, please expand on that. Can you just run through the example again? Okay. So does Jeeves have any choice in the agreement? Good question. Very good question. I like your thinking. Jeeves, if he knew what was going on, can have a choice. Jeeves can clearly state, I don't want any part of this. But if Jeeves is under an employment contract with the boss, I'm sure his contract would state that he should be taking any responsibility that the settlor so wishes him to take on board, within reason. As far as the practical elements is concerned, if you were to express a trust today, you would make someone aware that they have rights. But since we're in a wonderful world where ignorance of the law is no excuse, it's not your job to make them aware of their rights. And that's the doctrine of notice, okay? That's not your job, because they've never done that to you. And obviously you're going to be choosing or assigning competent, highly professional members of society who would be deemed to understand their responsibility and the office of trustee. So it's not for you to inform them of whether a trustee can say yes or no, or what we would say disclaim. That's not our job. In the law of trust, which I will be going through slightly, you don't even need to know that you've entered into a trust relationship to be in a trust anyway. All right? So that's what I'm saying, that we are all in trust relationships. We just don't know. And the law of trust, you don't need to know. Which is a very powerful concept, and we're going to use it for our own benefit. So another question here. So is this an absolute trust? I don't go into, that's all public stuff, right? Absolute trust, family trusts, constructive, all that business. No, we just do it private trusts. And as far as I'm concerned, that's all we're dealing with. So an absolute trust, which I think would be what you're trying to get at, is effectively what we're talking about. But I'm not dealing with the public, so it doesn't have a name beyond the fact that it's private and it's privately expressed by the set law. As simple as that. That's all we're dealing with. Nice and simple. Don't need to get bogged down in titles. I don't need a financial advisor to tell me what to do. I can create my own trust, and I can administrate my own trust once I know how to do it. Will this recording include your notes on the whiteboard? Yes, it will. Understanding of an absolute trust is where the beneficiary cannot be changed. Well, if that's the case, then yeah, it's a private trust is an absolute trust. But as I said before, what you got to get your mind around is you create a law of what you want to see. So if you create a trust where you don't want the beneficiary to be changed, then so be it. If you create a trust where the beneficiary has the rights to assign his title to somebody else if he so wishes to do so, that's in your law. That's my point that I was making earlier, that once you understand who you really are, you don't need to get into the rigmaroles of an absolute trust and all these different names. It's just what you say goes. It's as simple as that. And what you need to understand is you don't want the government to have discretion over your private trust, because then it's no longer private. So we don't give it titles in the public, because then it's governed by the laws of the land, which is nothing to do with you. You operate and exist in the private realm as a real man, so you express private trusts. And so it's only no one else can get involved with it besides you as a set law. It's completely irrevocable unless you say otherwise. It's your law. And this is what I've got to really highlight, the fact now, we don't deal with public or statutory instruments in whatsoever shape or form, because then it be discerned, which we don't want anyone discerning our documents. We don't want anyone having opinions about what we're trying to say. It's very much black and white, and there's no room for maneuver. There's no room to construe or make up what someone thinks I may have meant. It's in black and white, and it's there for no one to disagree with or to mix up in any way, shape or form. So it's absolutely imperative to understand who you are, that you are the lawmaker, and what you say goes, and it's in the private, and it's a private trust expressed by you. All right, so I hope I've made that very, very clear. So to go back over the example one more time, we have, King, so let's just say Queen Michelle, okay? And Queen Michelle owns a Phantom Rolls Royce. All right? Her son has reached age 21, and Queen Michelle has basically expressed a trust and says, right, Jeeves, this is her butler, notice you may not use the word trustee. She'll say, Jeeves, I want my son to inherit this this Phantom Roller. He's now 21. Here are the keys. Here's the V5. It's registered under your name. However, you are there only to pay bills. Okay, such as insurance, fuel. If he gets into trouble, I know he's a young boy, so he may get some speeding tickets or some fines. Just deal with it. I don't want anything else to do with it. Can everyone hear me okay? Yeah, okay, good. So, Jeeves, you're fully responsible. Here's my, I've written it all down and I've signed it. So, it's in your hands now, my declaration. And here's your responsibility. So the declaration tells you exactly what I want to see happening. I want you to, obviously you hold the keys. You allow only my son to drive this car, okay? Or if he asks you to drive it, then that's fine. We're not going to get involved with that. And then with regards to paying the bills or the fines, that's solely your responsibility. And you know what, Jeeves? Here's some money. I'll give you both pounds and dollars. So if anything goes wrong, any problems in the future, then you're the one to sort it out. All right? And I've given my son full authority to speak with you at any time. So he knows exactly that he should come to you if there's ever a problem. He knows who to go to. I've just created a trust. Right, so everyone's saying the sound's gone. I'm not sure what's happening here. I'm just going to... Can anyone hear me now, or is it still... Just type in Y if you can hear me. Right, okay. Right, we seem to be back on. I'm not going to write too much now. So effectively, as I said, got Queen Michelle. Queen Michelle has full rights, interest, and title to a Phantom Roller. The Phantom Roller, she says, well, I want my son to utilise it. And then because of this, because of my son utilising the Phantom Roller, then effectively I'm going to allow Jeeves to have legal title over the Phantom Roller. He pays all the bills. He sorts out all the insurance. He's the one that pays any fines. But my son, he's a beneficial owner. He's going to have full use of the car. He'll drive it. And that's it. That's fine. Okay? So what I'm going to do, if we just take, say, 2-3 minutes, just have a comfort break and come back. I think everyone's complaining about the sound. I'm just making sure everyone's okay, because I've still got a little bit to go through. A quick question, though, before we go on. So I could own a car, give beneficiary to the use of the car, but make the local police the trustees. In theory, yes. In theory, yes. The question is, would you want the police to be trustees? So it's all about justification. But yeah, in theory, you can assign whoever you want to be, as long as they're competent to do the job. Then yes, they can be trustees, no problem at all. Or use DVLA, as someone's suggested. But yeah, once you understand the theory, you can do pretty much what you want, as long as you can justify why. So what we're going to do is take at least just come back here. It's say 25 past. Let's come back at 1/2 to take a comfort break. Whatever you need to do, come back. I'm going to finish off about trust. Is that going to be okay for everybody? Because it's about 2 hours or whatever. So come back for 10:30, please, and then we'll continue. Thank you very much. To go. Right, so what I was just saying, there's a couple of questions come up, but just a quick recap, because I think people had problems with the sound, I'm not sure. Just a last recap, effectively, so Queen Michelle has full rights and titles to a Phantom Roller. and she decides, and in her wisdom, that she wants her son, age 21, to benefit and use the car. All right, just so when we benefit from something, it means we're enjoying it, enjoying its use. Everyone understand that? All right. So all she wants her son to do is drive the car, look good, dress good, do what it needs to do with a roller. All right. But in terms of the fuel cost, insurance, maintenance, everything else associated with owning a car, that's Jeeves' job. Everyone, just type in a Y if you understand that part. And if you don't, just type in a no, then I can at least move. Great, right, so we're all on the same page. So Jeeves is the legal owner, aka trustee. And so he has the administrative role of maintaining the car, paying the bills, any fines, etc. All right? Obviously, Queen Michelle has to put some money in trust also for Jeeves to work with. So she's put an asset that he can monetize or utilize to pay the bills with, because it's not his job to provide the money, it's just his job to administrate the money. Okay? So that's it. That's the trust. That's as simple as that. Now we've got some questions, and I'm just going to quickly find them. The first one, so if I made you trustee of my household bills, would there be no recourse for you? There wouldn't be no. The only recourse, if I accepted the role of being your trustee, the recourse would be you'd have recourse, full recourse against me if I failed to do the job. But you'd have to prove a trust existed in the first place. All right. I think the trust that was the question that was asked earlier was, so as Queen, why would I need to justify who I made trustee? Now you don't need to justify who you've made trustee in every single instance. But there will come a time when you're going to have to prove a trust. So the way we teach trusts, even though the law of trusts say that you don't have to necessarily write the declaration down, it can be via parole, i.e. you can give verbal decree, all right, and you've entered into that relationship, and as you know, the law of trust, the parties don't actually have to be aware that they're in the trust relationship in the first place. So you don't have to necessarily justify a trust, but the settlor must know, or one of the parties must be aware that a trust a trust relationship is being created. Now, let me give you an example just to make it a bit more clear to you. You've gone to the bank, okay? You've gone to the bank, and the settlor, by the way, is the one normally who signs. Okay, it's normally the evidence of a written decree. The one who signs is the settlor. Okay, and he signs an agreement, by the way, not contracts. Agreements are more powerful than contracts. So you've got the beneficiary here, and you have the trustee. Now, let's say the trustee is actually the bank in this instance. In other words, you deposit money with them. Their job is to create interest for you, and be available for you to withdraw funds back from them. Okay, so let's say that they're the trustee in this instance. However, they provide you're just living your normal life. You don't know about the relationships in a trust, but the banks do. The banks know they have no money. The banks know they're bankrupt. The banks know they can't generate any kind of wealth, so to speak, or print money without a real flesh and blood human being who's going to be the surety, the substance for their system. So you go in and say, hey, I want a loan. Okay, no problem. We'll give you a loan. And so therefore, what do? You sign a piece of paper. All right, so here's your nice, wonderful loan agreement. And it's called an agreement. And, you sign it. You're happy with the terms on there. But notice who wrote the terms on this agreement, because it wasn't you, was it? Did you write the terms? Just type yes or no. Did you write the terms? Exactly. So here are the terms, and notice that you didn't write it, but however, you did sign. Okay, now it's the agreement. It would have the bank's company name on there, but notice the main thing is it's got instructions or some form of declaration, and the lawmaker signs. You sign, not knowing what relationship you thought you were going into, what we call now a debtor-creditor relationship, but the bank, who understands trust implicitly, understands on the surface level it's actually a trust, but they've just called it a loan agreement, and you think you're going into a loan agreement. All right, so you are going in on the one relationship, which is a debtor-creditor one, but the bank and the people who devise this system understand, well, really it's a trust, but I can't afford for you, the true owner, to know who you are. I can't afford for you to establish who you are. I just want to see a signature on there and be happy with our terms and conditions, even though it's not conducive to you. So in other words, let's put it this way. You provide me with an equitable asset or some your signature, which represents your value. I put the terms and conditions so you think it's a loan, and therefore, even though I've not even lent you any money at all whatsoever, you're going to pay me back money every single month for the next 25 years. Sounds like a good deal to me. You believe it's a loan, so you think it's a debtor-creditor relationship. I, as a banker, know it's a trust, and you signed. And also, because you don't know you're in a trust relationship, I'm going to mess things around a little bit for you as well. I'm going to now operate in a general way, and I'm going to construe some relationships here. And the verb, the word construe comes from the verb to construct, by the way. Okay, so I'm going to make up some things because the law allows me to, called a constructive trust. So they're operating. There's different types of trust, by the way. So you've got your private trust, and you've got your general trusts. Yeah, you've got public trusts. So that's why I'm saying you don't want to get in the public realm. But at the moment, they're using public trusts against you, and a constructive trust is a type of public trust. It's not actually a real trust at all. It just allows law to progress, like the straw man. It's not real, but it just allows this system, this fiction, to move forward. So that's what a constructive trust does. So you get into the bank, and the banker, who actually is a trustee, has construed himself to be the beneficiary, because you've put your wonderful signature in there, which they can monetize, yeah. And because you didn't make it a specific situation, they can do what they want, because you've not endorsed yourself as who you are in this relationship. You've not said that you're the settlor. You've not said that you're trustee or beneficiary. You've just signed it, and so the bank said, "Fine, all right. I know who I am, but you don't know who I am, and the law says that you don't need to know that you're in a trust relationship. So since you signed, thank you very much, I'm going to take the role of the beneficiary, and I'm going to make you think that you're actually the trustee. So you're the one who's going to pay me every single month, every month without fail. If not, I'm going to make your life a living misery, and you've signed to that effect." Now, can you start to see how trusts are very powerful, but can also be very dangerous in the wrong hands? You can tap a Y if you wish, or no if you don't see it, and I'll explain a bit more. So that starts to now see why you need to establish your relationships. Okay, so can the trustee and the settlor be the same person? Yes, the trustee and the settlor can be the same person. So let me just go over that one more time. The settlor defines, creates, establishes a trust, and then the settlor is out of the picture. All right? There must be a beneficiary. There must be a trustee. All right? The trustee cannot be the beneficiary. The beneficiary cannot be the trustee, because they have separate roles. They have separate relationships, and they have separate titles. The trustee has legal title, and the beneficiary has beneficial or equitable title. All right, he has beneficial title. They're two separate, distinct titles. And once the trust is established, the settlor is out of the picture. It's just two parties. All right. If the beneficiary and the trustee decide to be one person, they have merged titles, and therefore there's the trust collapse. There is no trust. It's gone back to 1 plus 2 in terms of Title 1 and Title 2 have merged to provide one full title all over again. Alright, so the trustee cannot be the same as the beneficiary. They're two separate people. But the settlor can be either the trustee or the beneficiary, but it cannot be both. Alright, so the settlor, remember, they're three separate, distinct relationships. So once the settlor, his role is to create the trust. Once he's done that, he's out of the picture. He may decide to be the beneficiary, in which case he steps in as beneficiary and he assigns a trustee. So there's two separate parties. So the settlor can be the beneficiary. Alright? So what if the settlor does not provide enough funds to the trustee? Would this be a breach of trust? No. The trustee would just go back to the settlor and say, hey, I need some money. I can't perform my duties. I need money. I need more money. That's just the trustee can do that. Depends on what powers the settlor would establish in the trust in the first place. And this is why you need to understand that you're the lawmaker. You can do what you want and allow. But if you're not specific enough, the trustee, since he is now pretending to be you, really and truly, that's his job. He can actually construe and make up stuff as well. He can say, well, I think that if I were the settlor, then I wanted to withdraw another £5,000. And if you haven't put a restriction in your declaration for him to do that, there's no stopping the trustee. The trustees can be very powerful because they know their power, all right? But the beneficiary, if they understand what their power is, in the relationship is the most powerful out of the two. All right? So any more questions around that, just feel free to ask. But that's effectively how the basic mechanics of a trust. It's three parties. You can have any number of